for the justices of the Supreme Court and judges of the Court of Appeals of Kansas.
Forward. Arch. Color guard. Hold. Hold reverse. March. Color guard. Hold. Reset. Hold.
Oh, say, can you see by the dawn's early light what so proudly we hailed as the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming. And the rockets red, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does the star-spangled banner yet wave o'er the land of the free and the home of the brave?
Order. Hold. Bounce. Face. Colors. Post. Post. Up. Reset. Arcs. Order. Arcs. About. Face. Up. Forward. Arch.
Please join me in thanking the Color Guard from Washburn Rural High School and our vocalist from KU, graduate student, Miss Ashley Pooner. Please be seated. Good afternoon. Distinguished members of the House and Senate, Attorney General Schmidt, and other members of the executive branch, judges and justices, honored guests, and my fellow Kansans. I was recently watching a television clip that showed a man wearing a badge in a 1950s Western. And he was knocking down the bad guys with a few well-placed, powerful punches. And in true 1950s TV style, he wasn't really hurting anybody. He was supposed to be that famous Kansas sheriff, Bat Masterson. Now, for the tagline for this clip, it's a little bit off color for a state of the judiciary speech. But if you all agree that here I am only quoting from the television, I will share it with you. If anybody's easily offended, this is your chance to leave now. Have you braced yourselves? It said, Bat Masterson, a real bat ass. I've always liked Masterson. Mainly because he was my great-grandparent's sheriff. He was friends with Wyatt Earp, a fellow law enforcement officer in Dodge City and in Wichita. Abilene, Hayes, and yes, Johnson County were patrolled by Kansas lawman Wild Bill Hickok. Even Buffalo Bill Cody served as a government detective in Kansas. And yet another Bill, Tillman of Dodge City, wore a badge for almost 50 years. His legendary work provided the title for his biography, Guardian of the Law. The true adventures of these real Kansas law enforcement officers were larger than even Hollywood and TV could invent. We tip our hats to them because they kept the peace and enforced the law. We also tip our hats to the thousands of law enforcement officers in Kansas today who make the state a safer place and a better place. But even these dedicated men and women will admit that they cannot do this alone. Other Kansans must also qualify as guardians of the law. So today I will talk about some of these other Kansans, the 250 judges and 1,500 employees in your judicial branch of government who perform a critical role in providing public safety and who every day make a difference in the lives of their neighbors and fellow Kansans. This is a timely message because just last week, Governor Brownback declared in his inaugural message that, quote, every human should be protected in law, unquote. So let me illustrate this message of protection and public safety by showing how a typical criminal case in Kansas courts would work. Let's say officers suspect a man is keeping a kilo of cocaine in his house. The officers apply to a judge for a search warrant. Here is District Magistrate Judge Peggy Alford of Grant County in southwest Kansas. She represents our 79 district magistrate judges in the state. And she must decide, based upon the officer's affidavit, if probable cause exists to grant the warrant. Let's further say Judge Alford issued this warrant, and the officers found the cocaine as well as a stolen handgun, and they arrested the man. Based on these and other facts, the prosecutor files a complaint or information with the district court. In our example, we'll say the defendant is charged with a serious felony, possession of drugs with intent to sell. Here is Bernie Lumbreras, Chief Clerk of the District Court of Sedgwick County. Like many of the 700 other employees in our clerk's offices in our 105 counties, she accepts the complaint for filing to reflect the charges. She then starts a formal case file. Last year, Ms. Lumbreras and her fellow clerks handled almost 35,000 criminal cases filed in Kansas district courts. Cases where people were charged with doing harm to their fellow Kansans or their property, or both. Almost 20,000 of these cases were felonies. Next comes the first appearance, a hearing that must be held within 48 hours of the defendant's arrest, where the judge formally advises him of the crimes he is charged with committing. This is District Judge Jeffrey Jack of Labette County in southeast Kansas. Judge Jack conducts such hearings, just like the state's other 166 district judges. They may also be conducted by Judge Alford and the other 78 district magistrate judges. Here, the judge typically makes some initial decisions. Now, I suppose some of our judges might have pondered the hypothetical question of whether they would have sent the Royals' Alex Gordon home from third base. But here, they must decide the real question of whether to send the defendant home from jail, or whether to keep him behind bars for the safety of their fellow Kansans. The judge often makes these decisions about bonding and release based upon input from the prosecutor, defense counsel, and if he or she has experience with the defendant, from the defendant himself. In some courts, the judge will also ask for input from court services officers or CSOs. These folks, also known as probation officers, may interview the defendant in jail, determine his criminal history, and make recommendations to the judge. This is Brian Swinson of Saline County in central Kansas. Mr. Swinson represents the 350 CSOs in the state who can supply this information to the judge. Next comes a court proceeding called the preliminary hearing. Here, after considering the evidence presented, the judge must determine whether a crime has been committed and whether there is probable cause to believe it was committed by the defendant. If so, the judge binds the defendant over for trial and arraignment. This hearing, like some of the others that I mentioned, can be conducted by either district magistrate judge or district judges like Judge Alford and Judge Jack. As with many court proceedings, a court reporter may participate in this important hearing. Here is Marilyn Bailey, a court reporter from Thomas County in northwest Kansas. Like the other 130 court reporters in the state, Ms. Bailey records everything and produces a verbatim transcript. Like this. These transcripts can be valuable in this case's later proceedings in the district court, and they are indispensable on the case's appeal. Then comes the arraignment, where the judge advises the defendant of the charges for which he's been bound over and the possible range of his sentence, and where the defendant must enter a plea to the charges for the first time. If he pleads not guilty, the judge sets the case for trial. And because our example involves a felony, the presiding jurist here generally is a district judge, such as Judge Jack. A court reporter like Ms. Bailey generally is also present to make a record of the hearing. And additionally, there can be other hearings. In our example, the defendant may try to keep out of evidence the cocaine and the handgun seized through the search warrant, claiming they were illegally obtained. A judge must hear these suppression arguments and make these rulings, and the court reporter usually attends and makes a record of the hearing. Next is the jury trial itself, where Judge Jack and other district judges will preside. Sometimes the judge's administrative assistant attends the trial, acting as the courtroom bailiff. Typically, this assistant has coordinated the various schedules of the judge, the prosecutor, and defense counsel in order to arrange the trial. Here is Arlene Schumann, a judicial administrative assistant in Johnson County. Ms. Schumann represents approximately 150 administrative assistants throughout the state. Besides trials, they schedule hearings and conferences, and they perform many other administrative duties as the judge's right arm. Their work frees the judge to concentrate on the purely judicial functions. Ms. Bailey, or one of her court reporter colleagues, is also present in order to record the proceedings. She marks and controls the exhibits that are admitted into evidence, such as this stolen handgun. Clerks, such as Ms. Lumbreras, do things like summoning all of the prospective jurors and issuing subpoenas for the attendance of the trial witnesses. If the jury convicts the defendant, next comes the sentencing hearing. For the felony in our example, Judge Jack would preside, and a court reporter like Ms. Bailey would certainly record. Before this event, the CSO, such as Mr. Swenson, would conduct a pre-sentence investigation. This includes calculating the defendant's criminal history, the sentencing ranges for the crimes, and other relevant background information. Mr. Swenson's report would be filed with the clerk, Ms. Lumbreras, or one of her colleagues, and a copy would be given to the prosecutor and defense counsel. Judge Jack would use the report to help him decide the appropriate sentence. And because our example involves a serious felony, the defendant could be sent to prison and become the responsibility of the Department of Corrections. Depending on his criminal history, however, he might be placed on probation, supervised by a CSO like Mr. Swenson. Last year, Mr. Swenson and his 350 colleagues supervised the probation of nearly 17,000 people convicted of crimes in your communities. To put that in perspective, there are approximately 175 people in this courtroom right now. So if you look around you and multiply that by about 100. Now, if Mr. Swenson later believes that this man on probation is not meeting the terms and conditions of his probation, perhaps failing to check in with Mr. Swenson, he will file a report asking for the probation to be revoked. If the prosecutor files a motion to revoke, then Judge Jack will conduct a hearing, or he may decide to revoke the defendant's probation and reinstate it, sometimes with additional, more restrictive conditions, or to revoke and put him in jail for a while, or under the right circumstances, put him in prison to serve out his original sentence. Court reporter Marilyn Bailey will also attend. Administrative assistants like Ms. Schumann will help with scheduling the hearing. Now, this is a very fast overview of one example of the 35,000 criminal cases filed last year in the district courts of Kansas, which I have greatly simplified. Because our judges and employees handle many more types of hearings and do much more in the criminal justice system than time permits me to explain. The criminal law, however, is not the only vehicle that courts use to protect Kansans from those who would do them harm. Last year, we also issued restraining orders to protect more than 12,000 Kansans from abuse or from stalking by another. Protection from abuse that was directed toward an intimate partner or household member, including minor children, and protection from stalking that was directed toward an adult or minor children. Last year, our courts also issued orders to protect more than 6,000 kids who unfortunately qualified as, quote, children in need of care, unquote. By statute, this includes children who, quote, have been physically, mentally, or emotionally abused or neglected, or sexually abused or abandoned, unquote. These cases involving the safety of Kansans are just some of the various types of cases of the 400,000 cases handled by your courts last year. For we also decided approximately 105,000 civil contract cases, more than 9,000 probate cases, and almost 8,000 property disputes. But on the heartwarming side, we also granted nearly 1,800 adoptions of children. I assure you, our clerks, our court reporters, our administrative assistants, and our judges work just as hard on these civil cases as they do on the criminal matters that I mentioned. Oh yes, last year our court clerks, Ms. Lumbreras and her colleagues, also collected approximately $180 million. This included restitution for crime victims and monies for private judgments, for some state agencies, and for the general funds of counties and the state. Of that $180 million, we collected $54 million to fund state government. The judicial branch of your government did all this and more with an annual budget of approximately $133 million. This figure represents less than 1/2 of the entire state budget. Now, I don't claim to be a financial expert, but for these core services that our branch of government provides, that is, fair and impartial courts to administer justice for nearly 3 million Kansans, I believe most of those Kansans would say, this is a good investment. But it's not enough for me to simply say we provide these important services. I should also tell you how we are getting better in providing them. Again, because of time constraints, I will mention just a few. I will start with a reminder about our Project Pegasus. Pegasus contained a blue ribbon commission of 25 Kansans of various backgrounds, and its members performed the most extensive review of our judicial branch operations statewide since the 1970s. In 2012, they made recommendations to the Supreme Court for improvements. Pegasus also contained Kansas's first ever weighted caseload study. This allowed us to accurately determine by actual workloads how many judges and court clerks were needed and where they were needed. We have kept the weighted caseload study current by adjusting it based upon case filing statistics every year. These adjustments have allowed it to remain a valuable resource for the Supreme Court in making statewide personnel decisions. But by limiting its review to the workloads of only judges and clerks, this study had to leave out the important work of other employees such as you see today. Mr. Swenson and 350 probation officers, Ms. Schuman and 150 administrative assistants, Ms. Bailey and 130 court reporters, among others. So the Supreme Court has launched a statewide position inventory. We began working with our 31 chief judges across the state, some of who are in our audience today, to complete a comprehensive assessment of all judicial branch personnel needs, based not only upon our hard data, but also the experience and observations of chief judges and their employees. Our goal is to identify staffing levels that we need to provide efficient, effective, and timely service to Kansans. This inventory will also allow us to consider the impact of recent technological advancements on staffing needs. Speaking of technology, let me update you on our electronic courts project. I will begin with electronic filing, or e-filing. You all know that this allows lawsuits and related legal documents to be filed with the courts electronically. I'm pleased to report that implementation of a statewide e-filing system continues to forge ahead. Today's e-filing locations include both the appellate courts in Topeka and the district courts in 10 counties. These include Ms. Lombrera's Sedgwick County and Ms. Schuman's Johnson County with its GEMS e-filing system. During this past calendar year, more than 100,000 electronic filings were completed. We will continue to roll out this system statewide. Now, I told you in past years that e-filing will be integrated with the different electronic case management and document management systems presently used by court personnel in processing cases. In other words, through a complete centralized e-courts environment, we will shift from the present paper-based system to one that will provide judges like Alfred and Jack and litigants with immediate statewide access to case information, details, and records provided by the Kansas courts. Eventually, it will also allow our employees in any location to work virtually on court business in any other location. This additional advantage is a big one because it allows the Supreme Court to more effectively and efficiently manage the state's court system. The value of this e-court system was recognized by the legislature last year when it allocated approximately $3 million for this year and for several years to come. As for our increased use of other technology, we're making strides to expand video conferencing well beyond those district courts where it's currently used. This technology should save law enforcement, attorneys, and their clients the time and expense of traveling to courthouses for various hearings conducted by Judges Alfred, Jack, and their colleagues. The Video Conferencing Committee already has developed uniform rules and technical standards which it provided to the public for your comment. Those have now been issued to the district judges and their staff. Increased implementation of video conferencing is expected to begin soon in many more locations. We've also increased our efforts to collect more of the monies actually ordered by the courts, such as fines, fees, and court costs. The National Center for State Courts helped review our processes and to develop best practices and to standardize our collection methods. Acting on these recommendations will assure that court orders are taken seriously and will be enforced. They will also increase the receipts going into the public treasuries that I mentioned earlier. To help accomplish these goals, our Debt Collection Committee has recommended a number of statutory changes. For now, we have submitted 2 proposed changes to the legislature this session. We've also closely examined our increasing number of specialty or problem-solving courts. They obviously differ from the usual courts because they coordinate services provided to criminal offenders with direct, sometimes intense supervision by a judge. Many of these are drug courts, which attempt to address an offender's underlying substance abuse problems that often lead to criminal offenses, then more offenses even after convictions, resulting in a frustrating cycle that expends considerable resources of the corrections department and your court system. Our Specialty Courts Commission is currently establishing statewide standards for better serving the increasing number of users of this unique system. For the last 6 months, Johnson County has worked on creating our state's first Veterans Court. For those military veterans who have committed misdemeanors or lower-level felonies and who are eligible for treatment by the Veterans Administration. The goal of Veterans Courts is similar to drug courts. As one expert said recently, quote, to treat those veterans who have diagnosed conditions that are at the root of their behavior, unquote. District Judge Timothy McCarthy of Johnson County hopes to have this court operational by October. And I can tell you, as a Marine Corps veteran myself, and as the father of a soldier who served in both the Afghan and Iraqi wars, I personally really appreciate these efforts started by Johnson County to help the people who have served the country. Our Court of Appeals also continues its pilot project for mediating its cases, where participation is strictly voluntary and where the mediators serve at no cost. So far, 18 cases have been assigned to this project, and we look for more to come, because successful settlement of cases can save resources of Kansans and the appellate courts. Just as important, it can permit the appellate courts to concentrate their efforts on the other hundreds of cases that would remain on their docket every year. Similarly, the Supreme Court has looked at reducing, if not eliminating, those lawsuits in our district courts whose main purpose apparently is to abuse the legal system. One of our committees has developed guidelines for judges like Judge Jack to consider in deciding whether to restrict and how to restrict certain court filings from those litigants who have filed frivolous, malicious, harassing, or simply repetitive lawsuits and motions. As you can see, your courts are constantly trying to improve their operations through these and other methods, because the time saved through improvements can otherwise be spent securing public safety and enforcing the rights of Kansans. But rather than proceed alone, we continue to welcome your input. As with the Video Conferencing Committee report, the Committee on Abusive Lawsuits has also forwarded its recommendations to the public for comment. We hope the response is similar to the one we received when we asked for citizen volunteers to serve on our State Child Support Guidelines Advisory Committee. For those 4 open positions, we received 231 applications. But if you prefer a more direct communication with the Supreme Court justices and the Court of Appeals judges, you have that opportunity also. Numerous communities will be visited this year by the Court of Appeals as it continues its long-standing practice of hearing cases argued across the state. And beginning 4 years ago, the Supreme Court started a similar tradition. Most recently, on October 29, we heard cases argued on the beautiful campus of Kansas City, Kansas Community College. We had set that date many months earlier, and I have to admit, I had not foreseen that later that night of October 29, the Royals would be playing in Game 7 of the World Series in Kansas City. Judge Duncan from Wyandotte County, who was in the audience, in fact assured me that, Chief, if you can guarantee that when the court comes back to Kansas City that the Royals will be in the World Series, you're welcome anytime. This April, the Supreme Court will hear cases argued in a town that one of its judges calls Hays City, America. And while we are there, I will ask him to show me the streets where Wild Bill Hickok once walked as another guardian of the law. In closing, I want to thank you for coming here today and to thank those who are watching us right now on the internet, because having access to information about your Kansas courts is nearly as important as having access to justice in those courts. And as I did last year, I invite all of you to attend our reception downstairs and to participate in tours of the Kansas Judicial Center, which are available starting right here. And as you visit with us, please consider personally congratulating 2 Kansas judges. As I mentioned last January, 2 Kansas judges won national awards in 2013. But today, I'm talking about 2 more national award winners. 2 months ago, Judge Steve Lieben received the William Rehnquist Award from the National Center for State Courts, the first Kansas judge to receive this award in its 19-year history. It was personally presented in the United States Supreme Court in Washington, D.C. by the Chief Justice of the United States. And it was awarded for Judge Lieben's continual promotion of procedural fairness in our courts. And his Court of Appeals colleague, Judge Karen Arnoldberger, learned just last week that she is to receive the Burnham Greeley Award from the American Bar Association. It will be presented next month in Houston for her excellent work increasing the public awareness of the need for a fair and impartial judiciary. Now, unlike Masterson and Earp, Hickok and Tillman, these 2 national award winners probably will not be the subject of books, Hollywood movies, or TV programs. But the judicial branch is still very proud of both of them and what they stand for. All Kansans should be as well. Thank you again for your careful attention this afternoon, and I bid you all Godspeed. Thank you.
All right.